you.
Yes.
That using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I'm putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of the Techiman South, they feel secure to proceed because even if all the votes of the Techiman South were to be added to the petitioner's tally, it will not change the outcome. Yes. So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first respondent's chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew? Because I didn't do declarations.
You, as the witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 13,121,111.
Yes, because you stated so, the petitioner stated so in his petition that that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting it to you that you knew.
My Lord, you see,
the question.
I don't understand why you seem to be confusing me with the petitioner. because I don't understand.
You see, that's why we have to strike out some of the evidence, because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Oh.
Well, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner. Right. And I'm saying that I'm not.
So,
I took these figures from the respondent's declaration.
Now,
and before they were declared, I couldn't have known what he was declaring.
The figure at the time.
Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates Oh, my witness statement, okay. Witness statement. Have you taken? Yeah, you've taken the witness statement.
It's over there. Let me show you. Green book.
It's here. Paragraph 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe Mensah as cast, which is 13,434,574, the resultant figure would now be 13,562,592. Consequently, if all the votes of Techima South constituency were added to petitioners' votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techima and South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and then you can explain.
Okay.
Answer the question. I'm saying that at the time you were making this statement,
yeah,
you knew the exact results of the Techima South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if you are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techima South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techima. The respondent was justifying why she had to declare results based on uncompleted tally. And we are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting it to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Very well. Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that also?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
And I'm comfortable, I'm a teacher, my Lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total,
Yeah, the
total valid votes.
yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to these documents submitted by the first respondent.
Now, it is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way they have rendered it, that's why. 51.
0.5163.
Yes. 0.51261471. Is that correct?
That's correct.
Now, I am suggesting to you that this works to a percentage of 51.2614.
A percentage of what?
A percentage of the total valid votes also on this sheet.
263%.
That is correct.
Yeah.
Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct?
47.397. Yes.
Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned to the petitioner from that assigned to the second respondent and tell this court the difference.
Which of the numbers? You asked about percentage.
6,
you are now asking.
6, 7, yes, I've moved on from percentage. 6776066 minus 6265276. What do you get?
As it's not that good, I think you'll be stretching the witness.
About 510,790.
Thank you. Thank you very much.
It's okay.
Yes. It is, you got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded any votes as you allege. I am putting it to you.
My lord, I decline that assertion.
Now, in your Exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My lord, if you look at my statement, I indicated that I'll bring a sample of the constituencies and polling stations where padding took place. I did not indicate that that is an exhaustive list of all the places where the padding took place.
Sir, we are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put down there. Is that correct?
I brought it as a sample. I did it in my statement, actually indicates that this is from a sample of this particular constituency. I don't understand sample to mean a total of the population. Now, deduct the 510,790, you deduct the 4693 from 510,790. What do you get? With all due respect, I don't see the point of the
with the greatest respect, you are being rude to the court, not to me.
Okay. Yeah, come again.
I'm saying that deduct 4693 from 510,790. What do you get?
693. I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I am putting it to you.
My lord, I deny that because that you are subtracting apples from mangoes. Well, this is a sample. You want to take a sample from a population of another group. I don't see where the calculation is coming from.
You see, I am suggesting to you that you have no evidence to support your allegation, and that is why you have brought only what you have. I am putting it to you.
My Lord, we are not in court to try to declare another presidential results by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I decline that, my Lord.
Now, you had earlier told this court that you cannot speak to what happened in the strong room when your two representatives were there.
Yeah.
Is that correct?
That's correct.
My lords, on that basis, I'll end my cross-examination of the witness.
Yes, my lord, I do. So, Mr. Asiedu Nketia, you recall that before the declaration of 9th January 2021,
December.
9th December 2021, oh, relax. 9th December 2020, your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so?
It is so, my Lord.
And in those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was, by the votes you had collated, the president-elect. Am I correct?
My Lord, that is not in my witness statement.
No. Where is it? Yes, the paper. So can you answer that question? You did say so, didn't you?
Come again.
I said your party, including your good self, and the first petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press... So, I'm putting it to you that your party held a number of press conferences.
Yes, my lord, that is so.
Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections.
Yes, my lord.
The petitioner himself also spoke on the outcome of the presidential elections.
Yes, my lord.
And your as deputy, Tokuno, equally spoke on the results of the presidential elections.
My lord, I can attest to my statement at a forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke.
Now, you know that your presidential candidate, that is the petitioner, asserted that he had won the 2020 presidential elections.
My lord,
Ghanaians had voted for change.
My lord, what I remember the petitioner said was that the results as declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
My lord, unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that will give President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
My lord, there were all indications that he was going to become the president.
Not indications. I'm saying that by what you said, you meant that he had won the elections because that was the only way he could form the next government.
My lord, if I meant that, I would have said so.
Mr. Asiedu Nketia, we served on the petitioner our witness statement.
Yeah.
You are aware?
My lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware he has been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent,
Yeah.
we have attached Exhibit 6?
Exhibit
6.
this one.
This is ours. We are looking for our one. What is our witness statement? Our witnesses.
This is
Yes, can you answer?
Yes, I've seen this in a brown envelope.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained in there.
My Lord, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him. What he's saying. Now, at the time that he would have finished his evidence and stepped out, when we leave that evidence, he will not be available to respond to the content of that evidence. We want to play the video so that we will exactly. Yes, my Lord. Very well. Yes.
Mr. Kutuampa.
Yes, my Lord.
You are conducting your case. So if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you've not made any application. We have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
My Lord, may I, with your leave, make an oral application to have the video that we've attached to our witness statement played out, so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video
My Lord,
establish?
the relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election and that there was an attempt by the first respondent, together with, in collusion with the second respondent, were trying the will of the people, and that they had all the necessary pink sheets to demonstrate that they had won the elections. When they came to court finally, after a lot of pressure from the public that if you won, come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so there should be a rerun. It goes to their good faith and credibility in this matter.
Mr. Kutuampa, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I have won an election, that should be taken as the law?
No.
We have laws, we have regulations,
no.
And how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kutampa, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in. Yes.
My lords, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it, because it's part of our case, and use it to cross-examine the witness. And my lord, I'm saying that this is a difficulty.
You are talking about credibility. You want to establish credibility.
Yes.
Yes. So you haven't said so.
No, my lord, I said it goes to his credibility. I said so.
You have to premise your application in the rules, and you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
My lords, I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to
My application is for leave for the video.
Confront him with the exhibit?
Yes.
Okay.
Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of, and I have every reason to presume that you know that we'd like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have? Yeah.
I will take an adjournment.
My Lord, I respectfully, I believe that we have not been heard. There have been several steps of questions and so on. We have not been heard even in respect of his basic attempt. Okay.
Submission, the application. He said he was making an oral application.
Right.
Yes.
Yes, that's why I was saying that my understanding was that the question from His Lordship Justice Nketia was about the practicality of implementing that.
Yeah, it has not been granted. So we have to hear you before we can rule on it.
Very well.
Yeah, okay.
My Lord, in the first instance, it is a case of the petitioner that is being made by this witness. And therefore, evidence that he says is part of their case, that evidence has not yet come in. And your Lordship will see that, in fact, literally, whilst in the box, he opened that envelope. I mean, it was clipped. I think we all saw that. It was clipped, and he answered that, I mean, he has not seen that tape. So, my lords, in terms of the answers that he's given when the matters have been put to him, he has answered those matters. Now, the question now it is now being proposed that even before they bring in their witness statement with this flash drive, it should be put to him. That witness statement is not yet in evidence. It's not been adopted in evidence. So how my Lord, with respect, the procedures are simply being confused.
From this witness statement, which is, would I say, an invention into our rules. Well, you see, in some years back, before the coming to force of the, is it CI 37? 87. CI 87. Yes, you can just ask a witness under cross-examination that, please look at this exhibit. Did you append your signature to it or whatever? That was the practice. But yes, then you may even tender it through the witness under cross-examination, which was permissible. But of late, because of the CI 87, it is.
You remember, if you are conducting cross-examination, if you remember, you can pull out a document.
Yes.
And show it to the
the witness.
Yes.
Yeah. Lord, that document may not be in evidence.
My Lord, I have absolutely no problem.
So it's the same principle.
No, my Lord, with the greatest respect, what he was showing the witness was an attachment to a witness statement that has not yet been adopted. That's very different from the...
So it is not evidence yet. It's not evidence yet.
No, my Lord, with the greatest respect, I'm saying that your Lordship has described a scenario which is clear in terms of the procedure, other than the procedure that is being used now. In that procedure, that evidence would not be part of a witness statement or anything like that.
Yeah.
It would be a document that in itself can be tendered through the witness. And I don't have a problem with that. I'm just saying, my Lord, and I think with the greatest respect, this is also an indication of a problem arising from the fact that the case management process was truncated, with the greatest respect. Because, my lords, in the case management process, you would normally be able to indicate these materials which you would want to put to the witness. Then in the case management process,
your lordships would have the opportunity to make this practical arrangement that was being described by His Lordship Justice Amagenshi, whereby if that is a document or that is a video that they want to show and so on, that as a piece of evidence to confront him would be catered for. So, my lords, I'm respectfully making two very simple points. Firstly, in terms of the procedure that he's seeking to adopt, bringing in a witness statement and an attachment to the witness statement, that is irregular. Secondly, because that witness statement has not been adopted. So
it's not evidence yet.
Yes.
That is why they can do what they are doing. Because it's not evidence until they come to the box and adapt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document. That document is not in evidence yet.
That is why
so we are speaking the same. We are on the same level. We are on the same wavelength. What they have now, even though it has been filed, is not evidence. So they have it.
Yes, but my lords, you heard him. The application that he made is that it is part of our case that so and so.
Yes.
He said that.
Yes, so it's just electronic evidence. If it were any ordinary document, he could just give it to the court clerk to show it to Mr.
Yes, my lord, as you said, we're on the same wavelength in terms of the practice related to showing a document, a video, or whatever. We are absolutely on the same level. I'm just referring to the way in which he sought to bring it in through referring to the witness statement, which is not yet in, to a witness who is under cross-examination as the petitioner's witness. That's all. But, my lord, clearly, documents can be put to the witness under cross-examination. I don't have a difficulty about it. And that's why I was saying that the practical problem that we're in right now is because if in case management it had been understood, and I believe that was the question that His Lordship Justice Amagenshi was asking, if it had been understood that that document would be required for the cross-examination, then arrangements would have been made practically for that, because it happens to require some technology for it to be shown. So that is what I'm saying. And so we're in a situation where, the practicalities do not allow for the procedure that your lordship is referring me to, which I agree is a procedure that can happen under cross-examination. But because of the way that it was sort of introduced, we've ended up in this situation. So if we can, I suppose, go back to some case management and so on. And
all we need to do is to secure the equipment that can be used to play to the video to the witness. That is.
My lords, it was precisely because of this that when I got up, I sought to have directions of the court because of the new novel processes of witness statements and what it means for putting your case to
Mr. Kotamka, even if we were not in an era of case management prior, where you bring you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
We have actually notified the registry that we would be needing very well. Very well. My lords, but that is why I made the application.
My lords, whilst you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which he has testified and which is part of our witness statement, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because whilst we're discussing all this technology, I think very well. Exactly, that's all I'm saying.
You're watching our coverage and listening to our coverage of the election 2020 petition hearing. We've got into a very interesting point in this hearing, the beginning of the trial. We have Asiedu Nketia in the box testifying. The court is back.
The content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be played on the next agenda date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination. Please, you've not been discharged. So Monday, they may continue to conduct the cross-examination.
Very well, man.
Yeah, I will tell you.
We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well.
Thank you for your unsolicited assistance. Thank you for your unsolicited assistance.
All rise.
Well, the first witness to mount the box to testify following the filing of his witness statement, Johnson Asiedu Nketia, is done. He has not been discharged. He will continue with his testimony on Monday. The sitting has been adjourned. Before his cross-examination, though, Nana Addo Dankwa-Akufo-Addo's lawyer raised an objection based on the grounds that some paragraphs in Asiedu Nketia's witness statement were prejudicial, not based on Mr. Mohammed's pleadings, and scandalous. Therefore, he wanted those portions struck out, a position the EC lawyer agreed with. The court went on recess and returned with a decision striking out some paragraphs in whole or parts of Mr. Asiedu Nketia's witness statement as not based on pleadings on record, but the court also maintained two other paragraphs, 32 and 33 of the witness statement. So Johnson Asiedu Nketia, first witness, and he started with the EC's lawyer cross-examining him on the role of polling station agents as contained in the public elections regulations. There was also portions about their agents in the collation room. And then, of course, they took him back to the classroom, Kojo, where he did some calculations. A moment in this hearing that excited a lot of people. And then to this point, just quickly, what has been decided in terms of how we got to this point where the court had to adjourn sitting. There was some evidence that Nana Addo Dankwa-Akufo-Addo's lawyer, Akoto Ampao, wanted to show to the witness. That's the decision that the court says admissibility of that video will be determined in the next sitting, Kojo.
Just a quick update. By my count, 3 paragraphs were maintained, 21, 32, and 33. There were 4 paragraphs struck out completely, 6, 7, 30, and 37. And then 3 paragraphs had some parts struck out. 25, 26, and 28. So that makes up the total 11 paragraphs that were objected to in the witness statement of Johnson Asiedu Nketia. But how fascinating, especially the way the day ended on that. I don't even know whether it's an appeal. It's an application that the respondent is making or not. But
it is apparently
it's an application.
Oral one.
Right. So he's making an application to present some video evidence to refute the testimony of the witness, Asiedu Nketia. But in introducing this video evidence, he started off by, basically confirming to the court that this evidence was an attachment to a witness statement that has not yet been presented to the court. His own petitioner's witness statement. So it created an interesting situation to which Mr. Chikata objected, suggesting that, if it's not been presented to the court, it's alien to the court and should therefore not be accepted. We saw a bit of banter between Mr. Chikata and the justices, who were actually suggesting an alternative route, that if indeed the documentation or the video was to be presented just as a video, rather than an attachment to an as yet unpresented witness statement, then there may be a way for that to happen, except that it would need to be applied for, and there would need to be, the setup and so forth. So now we are awaiting their final ruling on this, whether they will indeed allow this video evidence, which, according to Akoto Ampao, is evidence to refute what Mr. Asiedu Nketia has said in the accepted paragraphs of his statement. So it's going to be fascinating on Monday to see, first of all, what the Supreme Court decides, and if they do agree to Mr. Ampao.
Absolutely. So whether or not the court will allow some sort of technology in the court, we will get to know that. But Mr. Chikata has also indicated that if they do allow that, then they would also want them to play back the declaration of the results as declared then by Jean Mensah, the Electoral Commission chair. Well, this is where we have to wrap up. We thank you so much for your company. Our election petition update is brought to you in association with Petrosol Clean Fuel in full quantity. It's always a delightful experience. DBS Roofing, we truly are your roof experts. Koa Mixture, the immune booster for your general well-being. My name is Mama Viusa here with Kojayang Singh. The court will continue its sitting on Monday. We will see the witness, Johnson Asiedu Nketia, continue his testimony.